Good morning. Merry Christmas, or at least Merry Christmas Eve. We've got 3 new filings in the Decastro versus Abrams et al. Case. So we're going to be going over those this morning. Really only this one matters. This is really the only one that matters. 11 pages. This is just a stripped down version of this, and this is 11 pages of absolute waste of everybody's time. So that's what we're going to go through. For those, I know, so I've been doing the camera in the corner. Let me know if you like that. I know some people really like to see the face of the person who's talking. I don't know that it adds anything technically. I don't think it adds anything, but it seems like some people really like it, and I don't know. Maybe I'll put a poll. I'm going to put a poll, I guess, in the description, and I'll probably put a link to it in a pinned comment as well. If you are interested in the face cam or not, let me know, and I can either leave it in or take it out. It really doesn't matter to me, and the roosters are really crowing right now, so that's pretty cool. But yeah, I don't care about my my clothes. This is a 20-year-old, 15 to 20-year-old shirt that I love, that's very comfortable. So if you don't like it, well, don't wear it. And yeah. Also, I get a lot of comments that like I think I know more than everybody else, and I don't think I know more than everybody else, but I am allowed to have a difference of opinion with other attorneys because I am a licensed practicing attorney in the state of California, and I can have an opinion on strategy. And if you don't like my opinion, then you don't have to watch my videos, and if you want to watch my videos anyway, just fully expect that you're going to be getting my opinion. And there you go. So the first document is the Notice of Motion in Motion by Josh Abrams to dismiss the first amended complaint and supplemental complaint. And I'm not going to read it because this is the same paragraph, and that's it. It's only just the one paragraph that is in this document, which is the memorandum in support. But this one has an added this part. Same exact paragraph, except it's added this. So we're going to go from here. So this is the memorandum of law in support of the motion to dismiss the first amended complaint and the supplemental complaint. And again, I disagree with conceding that it is a first amended complaint and supplemental complaint. I would have argued in the alternative. I would have done a motion to dismiss the second amended complaint with, in the alternative, a motion to dismiss the first amended complaint and supplemental complaint if the court construed the filing that way. So the preliminary statement. And again, this is the exact same thing as this with one sentence added. So he could have put the one sentence in here and skipped the supplemental complaint, but that's not what he chose to do. I disagree with he could have put it here instead of putting it in the preliminary statement. I disagree with preliminary statements, but most attorneys do use them. So I am definitely in the minority there when I prepare pleadings for other attorneys. Most often I will have a preliminary statement in it because that's what they expect. That rooster's really crowing. So preliminary statement. Now comes defendant Josh Abrams, who respectfully moves that the court dismiss the first amended complaint and supplemental complaint filed by plaintiff Decastro for failure to state a claim upon which relief can be granted. And that's 12b6. As currently pled, Decastro has only alleged one count against Abrams, copyright infringement pursuant to 17 U.S.C. 501 et sec. Given Decastro's admitted goal in this case, which is to vex, not win, Adams requests that this court dismiss not only the sole count against Abrams in the first amended and supplemental complaints, but also that the court reject any further request for leave to amend the complaint, and that such previously pled causes of action, i.e. defamation and intentional infliction of emotional distress, be dismissed with prejudice as well. Procedural background. Well, we know all this, but we'll go through it again, I guess. I oftentimes don't do a lot of procedural background. I don't think that it's necessarily very important, but in some instances I would do it, and this is an instance where I probably would put it in there, so I'm not disagreeing with this. On September 2, 2022, Decastro, and I normally include it, I normally put procedure and facts together in one, a combined procedural and factual background. Because it helps to, I just like one timeline. On September 2nd, 2022, Decastro filed a lawsuit against Abrams and co-defendant Kate Peter, a.k.a. Masshole Troll Mafia, Peters, alleging defamation-based claims, including defamation and intentional infliction of emotional distress. These claims purport to be predicated on statements made by Abrams and Peters on various YouTube channels during ongoing debate, commentary, criticism, and argument between the parties. On November 7th, so he's referencing back to the complaint, but the complaint doesn't mention anything about ongoing debate, commentary, criticism, and argument between the parties. That's interesting. So you got that's a fine line to walk as an attorney, trying to prejudice a court with something that isn't technically correct, but that's like this is his interpretation. This is Abrams' interpretation of it. This isn't Chili's complaint. It's not. So that's a fine line to walk. On November 7, 2022, Abrams answered Decastro's complaint and counterclaims against Decastro for various defamatory statements Decastro made about Abrams on YouTube. 2 days later, Decastro docketed a letter with the court claiming he had intended to dismiss his complaint without prejudice. See ECF 55, 56, 58, 59, 60, 66, 73, 80, 82, and 83 seeking similar relief. I'm so, like putting this in here to catch the court up. I mean, the court's really, really aware of exactly what's going on with that particular request. In each instance, citing to FRCP 741 and recognizing that both Abrams and Peter had answered the complaint and filed counterclaims, the court could not dismiss the lawsuit without the consent of the parties, citing all the times where the court said no, which again the court is pretty aware of, and that Abrams and Peter declined to consent to dismissal. It is believed Abrams believes that Decastro mightily attempted to have the defamation-based claims dismissed because he desires to refile it in a California court, making it more difficult for Abrams to defend given his residency in Massachusetts. Abrams believes that Decastro's intentions are to refile defamation-based claims in California to increase costs for Abrams. That request was denied as a blatant end run around the court's orders, rejecting his bid to dismiss the defamation-based claims for transfer to the Southern District of California. Decastro chose instead to amend his complaint. On November 16, 2022, Decastro amended his complaint to raise allegations of copyright infringement based on Abrams' alleged unauthorized use of Decastro's YouTube videos on his own channel. See the First Amendment complaint. The sole count of the First Amendment complaint is a claim for copyright infringement pursuant to federal statute. Decastro then filed, with leave of the court, his supplemental complaint, which purports to add YouTube and Doe's. The supplemental complaint does not include any counts, and it is unclear whether Decastro is pursuing any causes of action at all against Abrams at this juncture. See FRCP 8A1, requiring Decastro to plead a statement of the claim showing he is entitled to relief. So, I guess Garrick is leaving the door open to the court saying that no, the supplemental complaint is a Second Amendment complaint. But I would have made the argument for the dismissal of it. I still would not have conceded any of this. I might have pled it in the alternative, but I would not have conceded any of it. Factual background. Assuming without conceding that both the First Amendment complaint and supplemental complaint are both operative at this point. Okay, so that's good. He's not conceding that the supplemental or the First Amendment complaint is operative, which would mean the supplemental complaint is a Second Amendment complaint, so that's good. Abrams will draw the facts as set forth in these pleadings. Well, that's good because you have to, so thanks for saying the obvious. Abrams, who is pro se in this litigation, purports to teach constitutional law. I thought Garrick is still the man here. Decastro, who is acting pro se in this litigation, purports to teach constitutional law. Although Decastro does not indicate whether he is licensed to practice law in any jurisdiction, nor has he identified any law school or other academic institution where he teaches, he purports to teach law through video content that is published on YouTube. He alleges that both Abrams and co-defendant Peters, to save from having to create content themselves, are stealing his content on a grand scale. See, if you took out the bracket, it would be he alleges that both Abrams to save. So it doesn't make sense. Why wouldn't he say he alleges that Abrams, and then in the parentheses, as well as co-defendant Peter, end parentheses, are stealing his content on a grand scale to save from having to create content themselves? That's what I would do. Oh, we had a footnote. Did I miss a footnote? Oh yeah, okay. We had a footnote. Decastro also mentioned a civil RICO cause of action pursuant to 18 U.S.C. 1962, but failed to actually develop this claim in any manner whatsoever in the First Amendment complaint or supplemental complaint. To the extent Decastro believes this to be a viable claim, Abrams requests that it be dismissed as well. Decastro does not plead that Abrams is, like him, a constitutional law scholar. Instead, Decastro identifies Abrams as follows. Defendant Abrams' YouTube channel features videos of Defendant Abrams entering limited and non-public forums, libraries, child and protective support service facilities, city halls, post offices, to film employees and visitors in purposeful violation of facility policies prohibiting filming. Defendant Abrams then refuses to leave the facility when commanded, refuses to cease filming, and publishes to his monetized YouTube channel the controversial employee and visitor reactions that his filming triggers on video. As a fun and interesting side note, employees and visitors probably wouldn't apply. But this is the First Circuit, Massachusetts' First Circuit, so their understanding of the Gierke and Glick decisions, as laid out in the Veritas decision, would indicate that if it was a public official, then the forum analysis wouldn't matter as much. It would then have to be subject to reasonable time, place, and manner restrictions. Despite these varying purposes, as pled by Decastro, he pleads in conclusory fashion that Abrams and others copied Decastro's content for monetary gain in the same YouTube content market without consent. He makes no allegations regarding the purported effect of Abrams' conduct on the market for Decastro's content. Well, so this is a good argument, but it is fairly easily picked apart because Abrams does these as a First Amendment auditor. And the First Amendment, for those of you who aren't aware, is a fairly significant, or at least in the realm of constitutional law, there's a lot of law around the First Amendment, as opposed to, say, like Article 1 in its entirety, or Article 2. I mean, there's a lot of law around the First Amendment. There's a lot of stare decisis. There's a lot of decisions around the First Amendment and the extent thereof. And so I believe that the function of a First Amendment auditor is to, one of the things that they claim they do is that they teach the public and public employees about the limits of the First Amendment and things like that. So I could see Chile making a case that Abrams is, in fact, attempting to teach through actions the Constitution, or at least portions of the Constitution. So, there's another aspect of Abrams. I don't know. I think Abrams is probably does cop watching and things like that, and that's, that overlaps pretty substantially with Chili's purported focus. So he makes no allegations regarding the purported effect of Abrams' conduct on the market for Decastro's content. Decastro claims to have published over 800 YouTube videos on his YouTube channel. Some of these works were identified in Exhibit 1 to the First Amendment complaint. Although Decastro clearly, baldly, patently claims that Abrams copied and distributed Decastro's content, no such occurrence has been identified in either the First Amendment complaint or the supplemental complaint. The only video created by Abrams that is identified in any pleadings goes back to the now superseded original complaint. See the complaint, yada yada. In this video, number 2, it is believed that Decastro's complaint contains a Scrivener's error, as the YouTube link identified in that paragraph directs the reader to another unrelated video. The correct link is indicated in the text above. In this video, there appears to only be a glancing reference to Decastro's video that was edited in a way to present it in a satirical and critical manner. This alone is insufficient to support a colorable claim for relief. Argument: standard of review. In considering a motion to dismiss pursuant to FRCP 12b-6, this court accepts only the well-pleaded facts in the operative pleading as true. Legal conclusions and those factual allegations too meager, vague, or conclusory to remove the possibility of relief from the realm of mere conjecture must be set aside. Yes. So in order to file a complaint, it's notice pleading. But in order for your complaint to survive a motion to dismiss, the court will only use the factual allegations. So you can say, Josh Abrams defamed me in this video, and the damages are $75,001. And he's a resident of Massachusetts, and I'm a resident of California. That would be enough to put Abrams on notice as to what you are suing him over. So if you were going to get if you were going to go for a default judgment, if Abrams didn't respond, that would be sufficient for you to then proceed to a default judgment. You put him on notice. If, however, he files a 12b-6 motion, then the court's going to look at the actual facts in the complaint to make the decision. And legal conclusions, like, for example, Mark Stout's city halls are all limited public forums, regardless of the facts surrounding it. It's a legal conclusion. Those don't count. Those don't matter. So anytime that Mark Stout tells you that all you have to do to survive a 12b-6 is just plead that a city hall is a limited public forum, he's ignoring actual case law that says those legal conclusions aren't relevant to a 12b-6, to surviving a 12b-6. The court must then consider whether the remaining well-pleaded allegations are sufficient to support the reasonable inference. Oh, by the way, apparently, was it yesterday? I think yesterday, Mr. Stout got back to Kate about our potential debate, and he proposed, like a Wednesday at 3 o'clock Pacific, which would be 6 o'clock his time. I had previously told Kate that I don't normally get home until about 6 or 6:30, so I would not be available on a weekday until 6:30 Pacific, which would be 9:30 Eastern. And I said I would make myself available on weekends, pretty much any time, for a debate. So we're still, I think, negotiating the day and the time. So we'll see. And Kate also said, like, you know, now that I think about it, 6 o'clock Eastern would be terrible for me as well. And I'm like, oh, okay, cool. So let's not do that then, since it's not convenient for you, the moderator, or me, one of the debaters. There we go. I'm a master debater. Anyway, the court must then consider whether the remaining well-pleaded allegations are sufficient to support the reasonable inference that the defendant is liable for the alleged misconduct. Ultimately, the plaintiff must state a claim that is plausible on its face. Stating a plausible claim requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not suffice. Conclusory allegations that merely parrot the relevant legal standard are disregarded, as they are not entitled to the presumption of truth. And that is Iqbal, etc. Under this standard, Decastro's claims must be dismissed. And I believe they will be. I believe they should, unless... no, I think they will be. Yeah. It's just kind of weird that he filed this back in September, and now at the end of December, we're finally filing our first 12B6. I wouldn't have done it that way, but I wouldn't have made nearly as much money as Garrick and Wish did. So, I mean, they're smarter than I am, right? They have a lot more money for Christmas presents than I do this year. I guarantee you that. To establish a copyright infringement under the Copyright Act, Decastro must prove two elements. One, ownership of a valid copyright, and two, copying the constituent elements of the work that are original. Decastro has failed to meet this burden in both respects. Decastro has failed to plead an ownership interest in the works he claims is copyrighted. Ordinarily, ownership vests in the author if he can prove the work is original and complied with statutory formalities. Indeed, an author can establish prima facie ownership of his works if he obtains a certificate of copyright registration. Garrick is a better attorney than Wish. Save for registration, it is Decastro's burden to prove exclusive ownership of his works. Decastro has not pled in the first amended or supplemental complaint that his works are registered. He's also failed to plead that he has exclusive rights to these materials. And this is for good reason. Decastro has granted Abrams, among others, a license to use his works that are posted on his YouTube channels, as contained in YouTube's terms of service. Ooh, this is getting spicier and nicer. I like this. Rights you grant. You retain ownership rights in your content. However, we do require you to grant certain rights to YouTube and other users of the service as described below. And then let's go to license to other users. You also grant each other user of the service a worldwide, non-exclusive, royalty-free license to access your content through the services and to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it only as enabled by a feature of the service, such as video playback or embeds. For clarity, this license does not grant any rights or permissions for a user to make use of your content independent of the service. It does include to prepare derivative works. So, okay. By granting users like Abrams the royalty-free right to use and reproduce his materials, Decastro has failed, as a matter of law, to establish ownership in the works he lists. That is an interesting argument. So it allows them to access and to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it, only as enabled by a feature of the service, such as video playback or embeds. That's a good argument. I like that. I never thought of that. That's a good argument. Decastro's claims also fail because he has not identified. There's a light for the camera right there that just, it does make it a little hard to read, especially when things get near the top. It's a very bright little light. I don't like it I should get one of those ring lights so you can see little rings in my eyes and make it all pretty. But no, I'm not going to get a ring light because that's gay. Decastro's claims also fail because he has not identified in either the First Amended complaint or supplemental complaint any such copyrighted material that Abrams purportedly stole. While Decastro lists several works he claims to be his own, He does not once cite to any of Abrams' materials that allegedly used Decastro's copyrighted works. Instead, in a conclusory fashion, Decastro merely states that Abrams published Decastro's content for monetary gain. This is insufficient to survive a motion to dismiss under the well-established Iqbal-Twombly standard. Having failed to articulate any such works, Decastro's copyright infringement claims necessarily fail as a matter of law. And then footnote, the court may consider YouTube's terms of service in adjudicating this motion to dismiss. See Force versus Facebook, an appeal from an order granting a motion to dismiss, explaining that Facebook's publicly available terms of service are subject to judicial notice. Interesting. I did not know that. That's nice. I don't know if anybody else remembers when I was talking about judicial notice with the Stout case. There you go. Moreover, the terms of service may be considered because they are integral to the complaint. Interesting. A case alleging trademark infringement, considering a license to the trademark on a motion to dismiss because the license was integral to the complaint. Then we're going to get into a fair use doctrine argument, which is pretty good. The fair use doctrine, it's a good backup argument. I like his original argument. I think he should prevail on that, but it's always good to have a backup. Argue it in the alternative. If the court doesn't give you one, the court might give you the other. The fair use doctrine is a safe haven from copyright infringement. It creates a privilege for others to use copyrighted material in a reasonable manner despite the lack of the owner's consent. The fair use doctrine states, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. Will Abrams and the court is left to guess what works Decastro believes have been improperly used by him in violation of Decastro's copyright rights. To the extent Abrams has ever referred to Decastro's content at all, it constituted criticism, critique, and commentary that is excluded from the protections of the Copyright Act by fair use doctrine. I'm still going to call it, by the way, I think the court is going to give Chile an opportunity to amend his complaint so that he can make the allegations, he can identify the works, etc. That's what I would expect. I would expect the leniency from the court. While the First Amended complaint and supplemental complaint do not identify any such unauthorized use of Decastro's work, the sole video referenced in this litigation, albeit in the now defunct original complaint, is an edited 30-second clip where Decastro essentially states he is an undesirable person and a criminal, murderer, rapist, child molester, drug addict, alcoholic, animal torturer, worst person ever, etc. This 30-second segment was used by Abrams as part of an hour-and-a-half-long commentary and criticism of Decastro. It was not used to teach constitutional law or to compete with Decastro. It was used to criticize him. This is textbook fair use. Clearly. Peter, in her motion to dismiss, goes through the 4 statutory factors a court can consider. Thank you. Thank you for finally saying, refer also to the other motion to dismiss. Peter, in her motion to dismiss, goes through the 4 statutory factors a court can consider in conducting a fair use analysis in closer calls. While this analysis is unnecessary given the clear fair use of Abrams in the sole video, identified by Decastro in this litigation, Abrams adopts and incorporates the case law and logic cited by Peter in her motion. Thank you. Thank you. Thank you. See how much money you could save by just doing that? Like, boom, done. Vitally, where Decastro complains about a truncated 30-second clip out of Decastro's library of over 800 YouTube videos that does not talk about constitutional law, but instead is irrelevant to Abrams' hour-and-a-half-long debate, commentary, and criticism of Decastro, and where there is nothing in the pleadings whatsoever about market value of Decastro's work, it is clear that Abrams is not infringing on any copyrights owned by Decastro, and any such publication is protected by the fair use doctrine. Accordingly, the copyright claim fails as a matter of law and must be dismissed. To the extent Decastro's complaint could be read to discuss other potential copyright violations, Abrams is without sufficient knowledge to determine what those violations are, and he declines to guess. Thank you. Nevertheless, to the extent that Decastro identifies any other videos used by Abrams, it is likely that the use was similarly protected by the fair use doctrine. Excellent. 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 D, the civil RICO cause of action should be dismissed. Decastro referenced a civil RICO cause of action in the First Amended complaint, but it is unclear what facts he uses to support his claim. Indeed, none of the requisite elements necessary to plead a colorable civil RICO cause of action are articulated in either the First Amended complaint or the supplemental complaint. Accordingly, the civil RICO cause of action should also be dismissed with prejudice. E, oh, this is going to be the interesting part. Please have a good argument, because it would be nice if we had a good argument. I think the court, at this point, I think the court's going to allow Decastro to amend his complaint. But I hope he has a good argument. So go Garrick. Go Garrick. Give me a good one. Decastro has now filed an original complaint, the First Amendment complaint, and supplemental complaint in this action. He should not be granted leave to amend for a fourth time in any way that could potentially save any of his claims. This is because Decastro has used this lawsuit in a perverse manner, seeking not to win on the merits, but instead to vex the defendants. Decastro has brazenly admitted to these ulterior motives. I will break Peter and Abrams financially. They will have to hire a lawyer. I will file motion after motion and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them. That's a solid argument. Yeah, that is a solid argument. I wish we lived in a society where I could be like, yes, that will work, because he's a complete dickhole and he's abusing the process. He's abusing the system. I wish I could say with any degree of certainty that would happen. I'm still going to hedge my bet that the court's going to grant Chile another opportunity to amend his complaint. Here, where Decastro has already been given leave to amend twice before, the fourth bite at the apple serves only to further Abrams' vexatious motives. So where procedural, like rules of court, procedural things, like deadlines, the court should be much less likely to side with a pro se, to give a pro se litigant any more leniency than they would an attorney. Should be. But on preparing a complaint to sufficiently plead facts to survive a 12b6 motion to dismiss, that's a situation where a court is more likely to be more lenient on a pro se litigant than on a represented party. So I've seen Fifth and Sixth Amended complaints. So my gut instinct is that the court's going to give him that leave. The court's going to give Chile further opportunity to develop his argument and to plead the facts that are going to allow him to theoretically survive a 12b6. And then affirming blah, blah, blah. Similar in ruling on the motion to dismiss, Abrams asked this court to dismiss all claims, including the defamation-based claims in the original complaint, that have seemingly been abandoned with prejudice. Abrams is worried that Decastro has abandoned these claims intentionally so he can do an end run around this court's orders, declining to accept his belatedly filed notice of voluntary dismissal of the defamation-based claims. Abrams' concern is that Decastro may refile the defamation cause of action in a California court, a court that lacks personal jurisdiction over Abrams, a Massachusetts resident with insufficient ties to California. See, this is meaningless. Nothing in front of the court. There are no facts in front of the court to make a determination as to whether a California court has personal jurisdiction over Abrams, and it's not relevant to anything in this particular. That's wasted verbiage. That is, and indeed, I think it kind of cuts against Chile a little bit, because the court's going to say, well, then why not just file a motion to dismiss based on lack of lack of personal jurisdiction. So I would not have included that, but that's just me. Again, that's just me. That would be my personal strategic decision to not include that. It doesn't make it wrong, just means I disagree with it. The California court should nonetheless dismiss such a refiled claim, not only for a lack of personal jurisdiction, but under doctrine against claim splitting, which precludes a litigant from strategically pursuing in a subsequent suit claims which were or could have been brought against the original defendant in the original suit. Yeah. So again, I think this kind of cuts against his argument a little bit, because again, the court's going to say, well, then you just file a motion to dismiss based on claim splitting. Subject to reserving his rights to challenge an amendment on the merits, Abrams will agree to give Decastro one final chance to replead the defamation-based cause of action in a third amended complaint with Abrams' assent, so long as this is filed within 10 days of receiving this motion. The 10 days will likely have elapsed by the time Decastro files an opposition to this motion. So he filed this late on the day before Christmas Eve. And there's going to be 2 holidays in between, not counting Christmas Eve. There's going to be Christmas and New Year's. He saved this. He made a strategic decision to save this, to file it in such a manner with his 10-day window that appears gracious on the outside, but anybody who's actually going to think about it is going to be like, 10 days, that's kind of bull. And what I would see the court doing is say, well, you're not saying that he shouldn't have it, which is another bite at the apple. You're saying in a portion of your argument where you're saying that he should not be allowed to amend it, you're saying that you would agree to allow him to amend it, and then you're telling me that he won't amend it in that time. So you're saying that he would file an opposition to the motion and the 10 days would likely have elapsed. So the court's going to be like, you're being kind of a dick. You're pretending to give something when you're not. And I think that by doing it the way he's doing it and by conceding the things he's conceding, he's going to make it more likely that the court's going to allow Chile another bite at the apple. So, should Decastro decline the invitation, Abrams asks this court to rule that all claims raised in the original complaint are dismissed with prejudice and reject any further attempts by Decastro to amend the complaint as futile, unduly prejudicial, in bad faith, and in furtherance of Decastro's documented dilatory motives. And for the reasons stated, it should be dismissed, yada yada. So, all in all, I liked that he found the license that Chile granted via YouTube. So that's interesting. That was good. I disagree with his strategy, with Garrick's strategy. Doesn't mean he's wrong. It just means I disagree with him. So that was the motion to dismiss. Now we have Chile's late filed reply to Peters' opposition to motion for sanctions. Now, this document is entirely meaningless. It is a complete waste of time for Chile to write it, for the court to read it, for me to cover it. Waste of time. But here we are. And I know most of you will want me to say how dumb and stupid Chile is, since I've been beating up on Kate and Josh's attorneys. So we're gonna go and we're going to laugh at the retard. So let's have fun. Plaintiff's reply to defendant Peters' opposition to motion for sanctions. Decastro offers the following reply to the opposition memorandum from Peters' motion for sanctions. Opposition to motion for sanctions. Since I outlined the legal authority in my original motion, such information is not repeated here, and I do not intend by its omission from discussion here to concede any point previously raised related to contempt for violation of a court order. Now, normally in a reply, you don't re-rate. You don't have to re-argue all the things in your motion. Normally, a reply is a reply. So, if opposing counsel brings up a case in the opposition that appears to undermine or distinguish one of the cases that you have used in your original motion, the purpose of a reply is for you to say, oh, that case doesn't apply because of these reasons, because of because the fact pattern was different, because it had these facts and our case has these facts. So our case is more similar to the case that I cited because more of the facts align, or whatever. It's not an opportunity to, it's not supposed to be where you re-argue your motion. Your motion has to survive on its own. Your reply is only there to, again, try to poke holes in the opposition. He continues, however, Peter and her attorney of record have also participated in Rule 11 sanctionable activity in their opposition brief. Oh, wow. A Rule 11 sanctionable activity. FRCP 11b1 says that when a party presents to the court a pleading, written motion, or other paper, it is not presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Yes, by submitting a document to the court, the attorney is representing that it is not submitted for an improper purpose. However, he has to respond to your opposition. Although directed by this court to respond to my motion for contempt with a request for the shortening of time sooner rather than later, Peter and her counsel responded exactly 14 days after my motion for contempt was filed, delaying this court. They had 14 days. They had 14 days to respond. And they have always waited the entirety of time to respond. Wish is not a fast responder by any stretch of the imagination. That dude will wait till the last possible minute. And that doesn't mean that, I mean, imagine if you will, Ironton getting a copy of this particular argument made by Chili and saying, well, Chili understands that these deadlines need to be met, and he has a problem with other people waiting until the last day of the deadline because he thinks that's delaying the court, and yet he actually waits for days, weeks sometimes after the deadline to respond, and so he knows that he's delaying the court. But that won't happen. So anyway, it's just more evidence of hypocrisy on the part of Chili. And it's a shit argument, so it's the unnecessary delay. Yeah, what they're talking about there is to file motions that push back various things. Like, oh, I'm supposed to reply to this discovery. I'm going to file a frivolous motion opposing it just for the purpose of not having to reply to discovery and pushing that particular discovery response back, not because I actually have an argument about the discovery. Peter and her counsel also impeached themselves. They lied, Your Honor. They impeached themselves in the response, delaying justice for their offenses. Again, yeah. Just fucking what? Peter and her counsel also attributed a quote to me as a title in their pleading, not as evidence, but only in a way to harass or prejudice the court. It was not properly introduced. No one declared who or when the evidence was collected, who transcribed it, or the date of the video that it was taken from. Well, that's getting a little interesting. Let's take us a little peeky poo, shall we? David. Is it this one? This YouTube broadcast can be viewed here with a timestamp. I don't see what his problem is with it. It's not. It's not accurate transcribed, nor entered under penalty of perjury as part of a pleading. It doesn't have to be. You said it, dude. It can be used against you, just period. Peter allegedly quotes me in a YouTube video saying, I will break them financially. They will have to hire a lawyer. Did I find the right thing? Yes. I will file motion after motion and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them. Not only is the transcription not accurate, but the YouTube video is irrelevant to this case, and obviously. That's a terrible sentence. So if you're still writing these for Chili, you should be ashamed of yourself. It doesn't matter if the YouTube video is irrelevant. You said it. And there's that little statement that I like to say, anything you say can and will be used against you. It's an exception to the hearsay rule. Anything you say can be used against you. Opposing party can use anything you say against you. Anything. Doesn't have to be from a video that you believe is relevant. But if I remember correctly, you have in your pleading, you've linked to every single YouTube video. They're all as an attachment, links to them in your first amended complaint, I think. And there's more in your second amended complaint, your second amended complaint, titled supplemental complaint. So that video is not irrelevant to this case, and this is an action for contempt. So it would have to be relevant to the contempt. And I would say that it is, in fact, somewhat relevant to the contempt, but okay. I did previously warn Peter by email of the cost of litigation and damages for defamation to have her retract her defamatory video of me as outlined with evidence in the preliminary injunction request in ECF number 59. Okay. So that doesn't mean that you didn't say the thing that you... Let's do this. I don't want to do too much here. We're at 12:02. I will break them financially. They will have to hire a lawyer. I'll file motion after motion after. I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. Well, there you go. I don't think your argument's going to hold a lot of weight. I did previous warn, blah, blah. I warned her that I was going to break her financially, and so now I get to break her financially because I warned her. She has admitted in her YouTube videos to spending over $52,000 in legal fees to defend herself in this action, proving me right. Isn't it weird that this video is not relevant to this proceeding? This video right here, We Don't Stop Big Things Coming, is not relevant to this proceeding. Except, this video, this one right here, wasn't, it wasn't properly introduced. No one declared who or when the evidence was collected. Where are we at? Who transcribed it? Who transcribed it? The date of the video that it was taken from? No date of the video it was taken from. So literally everything that you just accused Kate of doing, even though you could just click on a link and you get a time-stamped link to where it is with an auto-generated transcript, everything you just accused her of doing, you just can't help but shit the bed. You are fractally stupid. And I've made no frivolous pleadings, written motions, or other papers in this court proceeding, except for the ones that the court says were. Indeed, she, with her counsel, has done it multiple times. Well, if you say so, there, buckaroo. Allegations of plaintiff filing court documents to harass. Much of Peter's opposition to my motion for contempt revolve around arguments that I am filing court documents to harass her. Yeah. Since my motion was for contempt related to this court's orders against harassment outside of the courtroom, her arguments are irrelevant and incorrectly transcribed quotes about me exercising my right to seek judicial relief are simply that, irrelevant, and should be stricken from her response. Additionally, this court has ruled on most of my serial motions without a response from plaintiff. Yes, the court could do that because they were frivolous, because they lacked merit, because it wasn't even a close call, because it was clear to the court, it was clear to the court that what you were saying was wrong and dumb. And the court didn't need any help figuring it out. The court didn't need to hear opposition. That's how bad, dumb, and wrong it was. Peter's Discord server. Peter admits to operating a Discord server with 2,800 users. Admits to having only recently posted rules for her server. No. And where is your declaration of who collected the evidence, or when the evidence was collected, who transcribed it, or the date of the video was taken from? But she said that she recently changed the rules, I believe, and Peter proves those rules aren't being enforced. Interesting. Peter admits to the screenshots that I introduced as evidence being made on her server, which violate the rules that she posted. That's your opinion, man. That's like your opinion, man. Peter has proven that the rules are posted simply as a facade. I don't think she did, but okay. Peter makes conclusory statements. Let's see. Conclusory statement, but then Peter makes conclusory statements that she is not responsible for the actions of other users, but under the doctrine of agency, which she is ignorant of, that's another conclusory statement, she is wholly responsible, conclusory statement. So would she be the principal or the agent in that particular relationship? Would the people who are violating the rules be her agents? And if so, like, what benefit is she getting from it? What agreement do they have? What are they acting as her agent in regard to? As a principal, if she openly says these are not my agents, how is that not a renunciation of any agency that may have existed? Why are you relying on them acting as her agents if she is denouncing them and saying that they are not, in fact, her agents? So who's ignorant of this? Like, please explain it to me and use small words, because I have not been a constitutional law scholar for 20 years. Peter has admitted to tracking me on the server like a great white shark, including the actions of her and her 2,800 trolls, always tracking my physical location. And how is this, speaking of relevancy, how is this relevant to contempt? Because she admitted this before the court's orders were in place. You have not proven anything, you've not shown anything subsequent to the court's order that she was still tracking you. And I believe she said that you were dumb enough that you would constantly broadcast your location. So how about that? I submitted as evidence screenshots from messages on her server that obviously, clearly violate her recently posted rules, yet the behavior remains and is used to target whoever Miss Peter is currently interested in targeting. As evidence of the misbehavior and her culpability, Peter has also recently, finally, quote, archived, end quote, the channel on her Discord server designed specifically to track me, named #ChiliWatch. Conclusory statements stating that is evidence of misbehavior and culpability. No. Stating that it was designed specifically to track you. No. Those are conclusions. Those are conclusory statements. While I initially appreciated Peter finally taking an action, and you know what? What the fuck are you doing on her Discord server, bro? What are you doing on her Discord server? Why are you stalking her, bro? I'm using the word stalking in the same context that Chili likes to use the word stalking, not as a legal term, because legally neither one of them are stalking each other, and him broadcasting his location and her having people on her Discord server making note of the location that he is broadcasting, meaningless. That specific Discord channel is no longer used to harass me and my associates, but the coordination of attacks is still being made, apparently on a... Oh, wait, hold on. While I initially appreciated Peter taking action, it was done for a nefarious purpose. It was done for more nefarious purposes. What are those purposes? And how do you know? Besides being psychic, how do you know? What did Peter say? Because anything she says can be used against her. So what did she say? Instead of making a conclusory statement, say, Peter said this, Peter said this, Peter said this, Peter said this, Peter said this. You can't seem to do that, though, so that's pretty dumb. That specific Discord channel is no longer used to harass me and my associates, but the coordination of attacks is still being made, apparently on a different platform. But is she associated with it? See, this is, you're making an assumption here, and you're even, apparently, this is an assumption. You're making an assumption. It's a conclusory statement and an assumption. Where are your facts? Videos made by Peter and her trolls continue to often mention a wealth of common location. Videos made by Peter and her trolls continue to often mention a wealth of common location and other data being collected and shared on me and my associates, obviously on a new platform with a better kept secret location. What video? Where? Anything that her trolls say can't be used against her, because they're not Peter. Anything that you say can be used against you, but anything someone else says can't be used unless somehow you get it in there. And the definition of hearsay is an out-of-court statement made by someone besides the opposing party, and offered for the truth of the matter asserted in the statement. So that would be hearsay. And what's a wealth of common location and other data? Like, what does that even mean? And collected by who? And who are your associates? And what new platform? Allegations of plaintiff doxing trolls. Peter says that she did not harass or, quote, dox, end quote, my associate, i.e. publicly identify him by name, address, and or other personal information. By name, personal information, like personally identifiable information, like social security numbers and health care identification numbers, things like that, things that are private, things that normally people wouldn't have access to, is entirely different than name and address. It's entirely different than name and address. Under her own definition, I have not doxed Todd Lyons. Who cares? Who cares? I did not provide the address of any trolls. Even if I did, I didn't run a troll farm. Even if I did, I don't run a troll farm that will then harass and vandalize that person's property. You haven't proved that she has harassed and vandalized your property. That wasn't even a cause of action. You had defamation and intentional infliction of emotional distress. What are we talking about here? And this action is specifically about contempt. So what has happened since the order was in place that specifically violates the order? I don't run a troll farm that will result in them and their family and employer being harassed endlessly by telephone, email, online, and in person. I get harassed endlessly by in person. I get harassed endlessly by email, online. I get harassed endlessly by online. Did anybody make that allegation that you run a troll farm? I'm interested only in removing a troll's veil of anonymity. I am interested in what you call doxing, is really what you're saying. The definition of doxing that you adopted, that apparently was supplied by Peter, identifying by name, address, and other personal information, is now what you're saying that you're interested in doing. Slow clap. For example, to let their mother know of the illegal behavior that they are doing. To contact their family by telephone, email, online, or in person and harass them, i.e., for example, to let their mother know of the illegal behavior that they are doing. We're faced with a choice here, folks. Number one, Chili is so blind to himself and his own hypocrisy that he doesn't see that he is literally just saying that he wants to do the thing that he's saying that he doesn't do, and that Kate does, but that he didn't do. Or Chili is a master comedian, a genius level comedian, who prepares these documents for the entertainment of the people who read them. This is not harassment. This is not harassment. It is actually the natural consequences that we learn in elementary school that results from bad behavior, as mentioned in the court's order at ECF number 51. You know, I remember when I was in 5th grade, and I called Billy Bob McGillicuddy a poo-poo pants poo-poo head. And then Billy Bob McGillicuddy doxed me on the local news, gave out my name, address, and personally identifiable information. And then he found my mother's phone number and called her to tell her about my illegal behavior. I remember that. That's what I learned in elementary school. Isn't that what we all learned in elementary school, you know? It's that, you know, you remember back when we were in elementary school and we learned to dox trolls and call their moms? You remember that? Additionally, Peter continues to allege that I'm partaking in threats of public exposure in exchange for affidavits, which we know isn't true, as she can offer no evidence. But as far as serial repetition of allegations to waste this court's time, this qualifies. Except that Todd Lyons filed an affidavit with the court saying that you were threatening to dox him in exchange for him signing an affidavit, or in order to compel him to sign an affidavit. And when did she continue to allege this? Where did she continue to allege this? What specifically did she say? And where can we see a transcript of it? Poking holes in the anonymity of online criminals is not the same as harassing members of my legal team who are doing nothing wrong. See, it's okay when I do it to them. It's just not okay when they do it to me. My legal team aren't afraid that their mothers or employees find out what they're doing. Then why do they care about being doxxed? They're afraid of the telephone calls, emails, vandalism, and other constant harassment to them, their families, and their employers that follows being doxxed by a troll farm. Because the troll farm is going to do what? Call and say that they're engaging in some sort of a bad behavior by assisting you in filing stupid things like this late reply to a motion that you've already lost and that is still lost and has not been reopened. Harassment of my associates. Peter says Ms. Peter did not publish a live stream video on November 12th, and in the thumbnail, Ms. Peter did publish a live stream video on November 12th, and in the thumbnail for the video used an image of a man whose identity she did not know at the time. Indeed, at the time Ms. Peter published the video, she understood that only this man had been entering group conference calls within her Discord server to take clandestine recordings. She did not know this Peter was in any way affiliated with Mr. Decastro. I am going to say, for the record, that I think that this statement by Kate was bullshit. I think she probably at least suspected that he was in some way, shape, or form associated with Decastro. So Peter knows that she did not own the copyright to the image she used. So is Mark going to file a copyright claim against her? And does fair use apply? I mean, just like, I hate to break this to you, but your associates aren't parties to this suit. And if they have a copyright issue with Peter, then they need to file their own copyright lawsuit against her. She admits to having done it to give him a little nod as a joke, a prank, if you will. Well, a picture, believe this or not, a picture is not a name, address, or personally identifiable information. Hello, baby. Okay, new sentence. Which may not rise to the legal definition of a series of such offenses, but certainly, clearly was in violation of this court's orders against harassment, especially given the language used at the hearing on October 24th, 2022, and all its orders against harassment and inappropriate behavior. Okay. But it clearly was not in violation of the court's orders against harassment because the court declined to find contempt. So, no. It's not certainly in violation of the court's orders against harassment. If it was, the court would have found contempt. If the court found contempt, then it would certainly be in violation of the court's orders against harassment. Peter has also perjured herself in making the above statement. How do you know this? When Abrams, we've now identified him as Abrams, great, Mark Abrams, when Abrams collected information from Peter's Discord server, he used his real name. So she didn't dox him. He doxed himself. And fucking stupid. Peter doxed Mark Abrams because Mark Abrams put his name, his real name, in her Discord server. He gave her his real name, and so she doxed him by using his real name or something. I don't know. I don't know. So she got the picture from his Discord account. Apparently he used his real name. What else is there? What else did she put up his address? Did she put up his address or his personally identifiable information other than the name and picture that he used already? Like, and posted in each channel on the Discord server that he had just scraped the data for the use in this pending legal action on my behalf. Where's the screenshot of that? Where's the screenshot of that? How did you get this information? Were you there? Did you see it? Where is his affidavit? You don't have firsthand knowledge of this. You're not claiming to have firsthand knowledge of this. You're saying this is under penalty of perjury, but how are you a percipient witness to this? If you're saying like, I saw this, I saw that, you're a percipient witness, you know it. Did you see this? Did you see him do this? And why aren't you showing it to the court? Obviously you had other screenshots from Kate's Discord server, so where are they? He also stayed to answer questions. Prove it. In no way would that be considered clandestine, and Abrams made it clear that he was working for me. Show us. Show the screenshot. The trolls keep emailing Adams saying that I doxed him when I put his email address in one of my filings. So who doxed him? Like literally. So he put his name out, he put his image out, and you put his email out. What did Kate dox? What did Kate dox at this point? It wasn't a secret that he was on my team, as previously mentioned. Adams had also signed his name to several court documents for me and other legal filings that are public record. Well, guys, if you didn't know that Adams had signed his name to other court documents in other legal filings that are court record, now you know, and I'm sure the autists on the Discord servers are busily at work going through every case that Chili has ever been associated with to find out if Adams has ever alleged that he is an attorney or anything along those lines. So congratulations, Chili. Like, you just like to get your friends in trouble or what? Like, you know how this is going to end. Well, if you're at all smart, you would know how it's going to end. And Adams does have a family. I mean, he's doing stupid things, but he doesn't need your help to F him over even harder. It's just that by putting Adams' personal email address in one of my filings that the trolls took notice and started harassing him. Peter's outright lying when she... So he made posts in the Discord server that you can't produce, that the trolls on her troll farm Discord server didn't notice, but they did notice emails in the exhibit, email addresses in the exhibits of your pleadings. They are tracking you across the country, identifying your information and other data about, identifying your location and other data about you, but they missed someone posting in their Discord and staying to answer questions. And it's not until people notice a email address in an exhibit to one of your filings that all like. We're only on page 5 out of 11. It's only 10:30, and I already want to start drinking. This is making me want to start drinking. Peter's outright lying when she says that she didn't know who Adams was or that he was working for me until my motion for contempt. Peter and her troll farm have had numerous discussions on every member of my team prior to her direct harassment and the harassment of her troll farm of them. Where? Show us these discussions. Since then, Adams has had threats not to participate in this action, along with threats toward his young daughter. Show it to us. Show it to us. Adams has also clearly been doxxed and has been told that he has been doxxed hard by members of the troll farm. Show it to us. Doxed hard to over 2,800 trolls. Yes, the same 2,800 trolls that he gave his name to, and he gave his image to, and he stayed and answered questions to. Apparently. Adams will no longer be participating because of these threats. Well, you know, that's probably the best decision he ever made. And he's not your lawyer, bro. Like, you don't have a right to have Adams participate. And what does this have to do with contempt? What does this have to do with contempt? I'm so lost. I don't like this. Someone give me a roadmap. Since this action has turned into a copyright one, and Adams being a well-known expert for copyright claims, a well-known expert for copyright claims. So apparently, he gave his name and address, and he's a well-known expert. But Kate doxed him. This doesn't even make sense in Bizarro world. Like, this is completely divorced from reality. Like, I have no idea what this dude is on about. So apparently, Abrams has had his research used in many court cases. Name one. Name one. And has been written up in at least one journal on copyright law. Well, why don't you name it? You've given us his name. Apparently his name is out there. Apparently he's doxed. So why don't you just... Why don't... Well, this took a turn. Since this action has turned into a copyright one, and Abrams being a well-known expert for copyright claims, having his copyright research used in many court cases and being written up in at least one law journal on copyright law, it is impossible for me to continue. What does that mean? Does that mean you want to dismiss the entire case? I would love to see how Abrams would be shown to be a expert. There's Daubert and there's Fry. I don't remember. California's Daubert. And I think federal's Fry. I'm not entirely sure which. Anyway, how would you qualify Mark as an expert? I guess maybe if... I mean, I would love to see his... So usually in order to be considered an expert, you have to give your CV, your curriculum vitae, showing like all of the journals that you've been published in, your work history, your education, anything you've had published, awards, things like that. Those are the things that the court's going to use to determine whether or not you're qualified to be an expert on the thing that you're talking about. Now, I don't know why you would want to bring a copyright expert in. That's the judge's role. Like, the judge is an expert on copyright law. That's the judge's role. I don't know what you would... The purpose of bringing an expert in, like if you bring in like a forensic expert, okay, so this is why the wounds look this way, and these wound patterns are indicative of a close range shot by a .32 caliber round. You can see the muzzle blast, the burns. This piece of lead here that might look indistinguishable from any other piece of lead to you is actually a .32 caliber bullet, and it's this many grains, and it's blah, blah, blah. And the expert is there to give the court and the jury an understanding of things that the court needs or the jury needs help understanding. But the law, the judge is the expert on the law. The judge understands the law. That's the point of having a judge. The judge is the determiner of what the law is and what the law says. And the judge is not going to give up that position of authority to somebody else, anybody else, even a let's just pretend like a retired Supreme Court justice. You want to bring him in as an expert on copyright law. That's not the court isn't going to defer to him. The court has to defer to any of his positions, any of his opinions, published opinions from the Supreme Court on copyright law or any other matter. But his opinion, that's not what you use an expert for. Further contempt by Peter. When did the court issue? So December 1st, the court denied his motion for contempt. And now Chili's bringing in further contempt after it. He has to file a whole new motion. He has to file a whole new motion for contempt. This is irrelevant. The court's already ruled on it. Like, I don't understand. Like, day late and a dollar short, dude. Like, you missed that ride. It's done. But anyway, on December 14th, Peter created a poll on our Discord server. The question in the poll was, should I do something dumb and self-sabotaging on YouTube out of boredom and woe and release a Chili video? Okay. See Exhibit 1, which I collected from Peter's Discord server on December 21, 2022, and is a true and correct copy. So Chili is in Peter's Discord server. Congratulations, you doxed yourself. Even though 176 trolls voted no and only 59 trolls voted yes, Peter did it anyway in contempt of this court. She made a Chili video. How can you prove that it was in contempt? You actually have to show it was in contempt. On December 19th, 2022, Peter released a YouTube video entitled Chili Decastro films his own arrest for criminal threats. Cyrax and Chili plot live on Facebook Live, which I collected on December 20, 2022, and the transcription is a true and correct copy. Transcription of Peter in the video below. I'm about to make a retarded decision, per usual. I got this video. Nobody else has it but me and the person who sent it to me, and I found it fascinating. And we watched it together in Discord. And I was like, should I show this? And I thought about it, but here's the thing. No matter what, I'm going to get hit with bullshit litigation because it is a clear abuse of process, in my opinion, at this point. So we'll have an announcement about the legal stuff at the end of the program. But right now, I want to show you guys, this is actually fascinating shit. So this is a charge from 2015, actually, that Chili took it upon himself to film. He sent it to the organization Photography is Not a Crime, PNAC, and they had less than complimentary things to say about him and the members that I spoke to over that were associated with PNAC at the time. So they really weren't too impressed with this guy. This is the earliest sort of contact that I've been able to find of Chili Decastro making any sort of even adjacent contact with the auditing community back in 2015. So this is your constitutional law scholar, everybody. This is not a copyrighted video, which inaudible. There are no protections as far as that goes. I'm always going to be adding some commentary, and I'm not really going to narrate too much of what happens in the video because Chili is going to tell you in his own words, and I'll just point out what I think is interesting. And then somebody else says something that is hearsay, and then who says this is just the beginning? I don't know. In the video, Peter also described me as a fucking retard. But is that contempt? Or is that true? She describes me as a fucking retard that is smearing shit on the wall in reference to this lawsuit, which she has entered into because she admits that she doesn't like being told what to do, including by a court, but especially by men due to her previous abuse. Now, isn't it weird that he actually provides quotes for up here, but then nothing down here? Isn't that weird? Isn't that weird? That's weird. Isn't that weird? Isn't that strange? The contrast of the specificity of this with the generality of this would lead one to believe that this is an accurate quote and that this is Chili smearing shit on the wall because he's a fucking retard. The video makes her contempt for this court's orders abundantly clear. Now, this is what she said. And is she harassing him? Bro, it's the internet. Turn off your computer. Additionally, she says the video had no copyright, showing her complete disregard for copyrights of others. But she also alludes that she's going to be using it with fair use. She says, I'm always going to be adding some commentary. commentary and critique, fair use, which you didn't pick up on. So who doesn't understand copyrights? Since video hadn't previously been published, it was a clear violation of my copyright, and blatantly violating my copyright was a further harassment and contempt of court. Well, that's funny that you should say that it wasn't published, because somebody else had it. You published it to them, and then they published it to her. And then she is now publishing it to everybody else. So it had been previously published. That's how she got it. Peter is a serial harasser and victim blamer in contempt. We're almost done, kids. Peter appeared in a YouTube video by a journalist for Turtle Boy Sports on December 16, 2022, where she was leaving her arraignment for continuing to troll one of her trolling victims in violation of a restraining order, saying, "Get your little victim away from me." Under Massachusetts general laws, this court should be able to consider Peter's recent conviction against her credibility. So the only time that a court can use a conviction against someone's credibility is if it's a conviction for something like fraud, where the thing that you're convicted of involves some level of dishonesty. If you're convicted of murder, that doesn't mean that you're a liar. It means you're a murderer. If you're convicted of fraud, that means you're a liar. So the judge may allow testimony in about you being about the fraud conviction, as long as it's more probative than prejudicial. And the Massachusetts general laws about admissibility of evidence, there is federal rules of evidence, and that's what you use in federal court. You use the federal rules of evidence, and there are rules about admissibility. And so, it does. You're citing the wrong laws, brother. This court should be able to consider Peter's recent conviction against her credibility. Was she convicted? He talks about arraignment and then conviction. So, arraignment, conviction. I don't know. I did not hear that Kate had been recently convicted of anything. So that would be cool. But you know what is defamatory? Just as a generally speaking, is alleging that someone has been convicted of something when they haven't. That's usually, it's not necessarily defamation per se, but one could, generally speaking, find that that's defamatory. Whether or not there are damages involved or you can collect on those damages is a different thing. But saying that someone has been convicted in a declaration under penalty of perjury when they haven't, I'm just saying. Like it should already be considering defendant Joshua Abrams' multiple felony convictions against his credibility. Was he convicted of anything involving fraud or I'm going blank on anything that has to do with, but it's anything that where you have to lie to get something. It's any conviction for a crime that involves being a liar. I thought you had accused Abrams of, was it rape and domestic violence or something like that? I wasn't aware of any convictions by Josh Abrams for anything regarding fraud. This evidence should also be submitted toward her pattern of harassment, especially in contempt of a court. And there you go. And yeah. He has a prayer for relief. That's pretty cool. Any other relief the court finds appropriate. That's pretty cool. Man, that's pretty cool. So anyway, we have exhibits. Should I do something dumb and self-sabotaging on YouTube out of boredom and woe and release a chilly video? Thumbs up is yes. Thumbs down is no. And yawn is delete your social media. Well, he didn't put that last part in there. So I would say that this makes it appear that this is done satirically. This is, yeah, it's not. Oh, here we go. That is a lovely shot of shiz. That's rough. And there you go. What are we looking at this for? I don't know. I don't know why we're looking at this. I'm looking to figure out why we're looking at this. And so I guess Chili really enjoys watching Kate's videos. Okay, Exhibit 3. After leaving arraignment. So she said that after being arraigned, not being convicted. And it looks like she's trying to get into her car. So, okay. And this is hearsay. So there you go. Well, I guess any statements that she made in it would not be hearsay because it can be used. Anyway, there you go. That's probably insanely long. Lord have mercy, an hour and a half. Well, thanks for watching. Have a great day. Oh, and Merry Christmas.